This begins the videotape deposition of Don Perez. Today's date is January 4th, 2019. The time is 2:15 p.m. We are at 2200 Paseo Verde Parkway in Henderson, Nevada, 89052, for the matter entitled Clint Kester versus Don Perez. Case number D-07-384243-Z. In the District Court, Family Division, Clark County, Nevada. I am the videographer, Andrew Jones. The court reporter is Lisa Mikowski with Turner Reporting Services. Counsel, please identify yourself.
This is Attorney Matthew Friedman, the law offices of Ford and Friedman. Present with me today is Ms. Perez, Don Perez. Don, can you please state and spell your name, actually, for the record so they have it?
Don Perez, D-A-W-N-P-E-R-E-Z.
Okay, and Don, what I'm going to go ahead and do is I'm going to have them swear you in now, if you wouldn't mind.
Please repeat. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Just a bit of soliloquy so that we understand what we're doing. This deposition was originally set to commence at 1 p.m. today, and Ms. Perez did show on time. She fulfilled that duty, and she took the opportunity to spend some time with me discussing the merits of the parties' respective cases. And what we've done today is reached a global resolution on all matters, such that we will be drafting and submitting a final order modifying custody and putting these matters to rest. What we are going to do today, however, on this record, is, now that Ms. Perez has been placed under oath, and I'll explain that to you in a moment, is we are going to summarize those terms, the terms of our agreement, and ensure that Ms. Perez understands them and that she affirms them and effectively gives her consent to the court adopting and ratifying them as its orders. As you are acting as your own attorney, and do you prefer Don or Ms. Perez? Do you prefer Don or Ms. Perez?
Don's
Okay. As you are acting as your own attorney, Don, you understand that you have the ability to bind yourself legally. So when you affirm to something, it's just as though your attorney could do so here. Were she present, right? What you say today will be binding, and you understand you just swear in and we're given an oath today, correct?
Correct.
Okay, and you know that that's the oath that you would be given in any courtroom across the United States of America, correct?
Correct.
And what that means is that when you answer a question under that oath, that the truth of what you're saying is essential, and that to the extent that you are not giving honest testimony, you're subject to essentially contempt of court and potentially perjury. So it's very important that when I ask you a question here today, and you give an answer, that you give the most truthful answer possible. Okay, you understand that?
Yes.
You also understand that because of that, we're entering into a binding agreement today. This is going to effectively be it. We will be done. We'll have to submit something in writing, but this will be it for us, okay?
Okay.
Okay, so if at any time you don't understand what I'm saying, make sure that you clarify it. Because if you answer yes to a question, if you affirm that you understood it and you answer yes, it's going to be yes for posterity, okay? Does that make sense?
Yes.
Okay. So what we've gone ahead and done is resolved what is effectively a pending custody dispute. Is that right, Helen?
Yes.
Okay. And in particular, this custody dispute relates to your remaining two minor children with my client, Mr. Kester, specifically Avery and Kobe, correct?
Yes.
Okay. And I say remaining because your eldest child, Lilani, is emancipated, correct?
Correct.
And is no longer the subject of this litigation, right?
Right.
Okay. So what we've done is we've come up with a slew of agreements and terms, provisions that are going to resolve with finality the litigation and the issues between you and Mr. Kester. Is that correct?
Yes.
And the terms, which I will place on the record here in a moment, you believe them to be in your children's best interest, correct?
Yes.
Okay. And you were not coerced by me or anyone else to enter into the terms of this agreement? Okay. It's important that because she's keeping a record, it's important, and this is informal, this isn't formal, but because she's keeping a record, make sure that I finish speaking before you answer. Otherwise, we answer over each other and it's difficult to read, okay?
Okay.
Okay. And I'll tell myself to try and talk slower because I do a really bad job of that. Okay, so let me try that. So, okay. So I'm going to now go through the terms, okay? And I'm going to ask that you confirm in your understanding and that in your agreement to each of them. So the first term that we're going to make part of our permanent order is that you will communicate regarding all matters relative to the care, custody, maintenance of Avery and Kobe solely through Family Wizard, our Family Wizard. Is that correct?
Yes.
Okay. You understand our Family Wizard is an electronic application that you are able to use on, I believe, computer or cell phone to do all communication with my client, anything regarding the minor children, correct?
Correct.
Okay. You understand that it is your obligation to make sure that you are enrolled in our Family Wizard, that you have access, that you have your passwords, and that you are regularly checking it, okay? You understand that?
Yes.
Okay. You understand that it would not be a sufficient excuse to say, I didn't see it, or I didn't get that, right? You have an affirmative obligation to make sure you are checking it at least daily to know that you are not missing something in there because you won't be getting the information any other way. You understand that?
Yes.
Okay. Now, the sole exception to the Our Family Wizard protocol is what I call life and limb. Okay, so if somebody is bleeding, somebody is expiring, heaven forbid, if it is an absolute emergency and there's no possible way that an electronic communication could suffice, we may use the telephone in that situation, okay? But anything that is not, as I say, life or limb, our Family Wizard is going to be your sole means of communicating. Is that correct?
Yes.
Okay. Now, at issue for our upcoming trial was ostensibly the modification of custody, both physical custody and legal custody. Do you recall that?
I do not recall that.
Okay. Is it that you don't understand what I'm saying, or that you don't agree that that was what was at issue?
I remember that it was mainly the physical custody part of it.
Okay. I will represent as an officer of the court that what we would have been litigating there, without, irrespective of how it may have turned out, was potentially a modification to physical custody and to legal custody as well. Okay? But regardless of that fact, did you and I have a conversation? Have we had many? And did we have, in fact, a lengthy conversation and discuss both physical custody and legal custody today?
Yes.
And did we reach agreements on both of those issues?
Yes.
Okay. Now, the agreements as I understand them are as follows. As to physical custody, you have agreed that physical custody shall be modified such that Clint, Mr. Kester, shall be designated as the primary physical custodian of both Kobe and Avery, and that will be a final order of the court. Is that correct?
Yes. Yes.
Okay. With regard to Kobe, in terms of his visitation, we will not have set visitation, meaning set days or times. However, he shall enjoy teenage discretion. Is that correct?
Yes.
Okay. And you understand teenage discretion means that basically he can dictate and determine when and where and how he exercises visitation with you. Okay?
Correct.
And that will be free from any influence, coercion, or pressure by you, correct?
Correct.
Or by Mr. Kester as well, okay? This should be his and his alone to determine. Obviously, love him, care for him, treat him great. Nobody's saying don't do that, but the idea of, it should be his decision where he wants to be, okay?
Okay.
That's clear, okay. Now, as to Avery, Clint shall still have, it will be primary physical custody, but we are, because of Avery's age, he's not yet even 14, he's still 13 years old, Avery is going to have set visitation, and his set visitation with you is going to occur on the first and third weekends of every month. Is that your understanding? Is that correct?
Yes.
Okay. And what we've decided is we've designated those weekends such that it will be the Saturday. So the first Saturday of every month will be deemed the first weekend, and the third Saturday of every month will be deemed the third weekend. And those will be your custodial weekends. Is that correct?
Yes.
We've further agreed to delineate the times of those weekends as follows. The weekend shall be deemed to begin Friday after school. And if school is not in session, it will begin at 3 p.m., correct?
Yes.
And that weekend will conclude Sunday evening at 8 p.m. Is that correct?
Yes.
Okay. Now, you understand that just because we designate the weekend as being the Saturday, you'll actually start it on the Friday, right? That's clear to you?
Yes.
It's just a means of always knowing which weekend is yours, right?
Yes.
Okay, wonderful. Now, Avery will not have the teenage discretion that Kobe has. However, we did agree to a protocol for Avery that gave him some voice in these proceedings. Is that correct?
Yes.
Okay. And specifically what we've agreed is that Avery is entitled to raise a reasonable objection to not wanting to continue a visit. And that if Avery should raise an objection, if Avery should sincerely say he wants to go home, he does not want to continue the visit, that you will not interfere or obstruct his ability to do so, correct?
Correct.
That you will contact Clint and that you will make sure that Avery is able to conclude the visit, correct?
Correct.
Okay. So Avery, while not having teenage discretion, will be entitled to terminate a visit if for whatever reason he believes he needs to, right? And I've encouraged you, although it's not, and let me say this expressly, it's not going to be in an order, but I have encouraged you, and I will encourage Clint the same, that I don't necessarily believe this is something that should be discussed with Avery. I think, while I'm not saying this is an order, but I think this is something that you guys should simply have a conversation with each other and make sure that you are aware and that Clint is aware that it exists, right? I think that Avery should simply do as Avery does. And if he expresses a desire to go home, that you don't stop him, right? And that's how I believe. The order, however, is just going to say that Avery is entitled to object. Should he object, you will not interfere and you will allow him to conclude the visit, correct?
Correct.
Okay. That will conclude the physical custody modifications. With regard to legal custody, currently you share joint legal custody, correct?
Correct.
Okay. Now, we are not going to disturb the designation of joint legal custody. However, what we are doing is entering into a protocol that I refer and some of my fellow practitioners refer to as modified joint legal custody, okay? And we discussed what modified joint legal custody means, correct?
Yes.
And while I did not give you legal advice, I did my best to explain the legal concept to you, correct?
Yes.
Okay. And to summarize, I explained it as follows. You are still a joint legal custodian for all purposes regarding access to information, documentation, and the ability to have opinions and express those opinions regarding education, religion, medical decisions, so on and so forth. Typical legal custody issues. However, the modified portion, why we call it modified, is that as Clint will be the primary custodian and will have these children the majority of the time, he shall be empowered to make day-to-day decisions concerning their care and maintenance, legal custody decisions specifically. He shall be empowered to make legal custody decisions without your approval, without your prior approval. Is that your understanding?
Yes.
Okay. Now, I explained to you and was clear, this does not mean that it's a death knell to your ability to contravene a decision. It's just that he does not need your prior approval. So, if he makes a legal custody decision in the course of being a parent, which if we're parents, we all know we make lots of those all the time, okay? And you find out about it and you have a disagreement with it, your recourse is, obviously first, you can notify Clint, and second, you can take issue with the court and bring it to the court's attention. But Clint does not have the duty, which would typically be incumbent upon a joint legal custodian, to get your consent and get consensus prior to acting. He can act, and then obviously if you object, it would then the burden fall to you to do something about your objection. Is that clear?
Yes.
Okay, and you agree that will be a binding order of the court, you want the court to adopt and ratify that term?
Yes.
Okay. Now with regard to child support, which it flows off of custody, You recently filed a financial disclosure form with the court. Are you aware of that?
Yes.
Okay. And that was through your prior attorney. I forget her. Was it Goulet? Is that
Yes.
Ms. Goulet, who I think just recently withdrew from this case, right?
Yes.
Okay. But nonetheless, she filed that financial disclosure form. And that disclosure form reflected that your gross monthly income was the amount of $3,443.33 per month. Is that correct?
Correct.
Okay. Now, I know that you're not a family law attorney, but we did discuss child support formulas and how child support works in the state of Nevada. Is that correct?
Yes.
Okay. In particular, the applicable statutes is NRS 125 B050, or excuse me, B070 and 080, 125 B070 and 080. And in the Rivero case, I guess, as well would apply here. Effectively, what those statutes and what that case law indicates, at least for the time being, because it is set to change, but for now, the governing law is that for 2 minor children, a primary physical custodian shall receive from the non-custodial parent child support in an amount equal to 25% of the gross monthly income of the non-custodial parent. So in this case, that math would work out to be 25% of your $3,443.33, which is the amount of $860.83 per month. Okay? That would be your child support obligation paid to Clint, for Avery, and Kobe. Now what we've done to make life easy is we've rounded out that 83 cents. So we're going to call your child support obligation $860 a month. Is that correct?
Correct.
Okay. Now, we have agreed, we discussed Venmo as a means of payment, and you had raised some concerns about the security of it, but what you have pledged to do is that you will ensure that that money is set up on an auto payment so that it is being received by my client without you handing him a paper check or cash, that there's some form of automatic ACH, something of that nature, you will ensure that is done.
Yes.
Correct?
Yes.
And it's your obligation to do that, correct?
Yes.
Okay. Now, as in for the timing of it, you explained the way you were paid, right? And we had some conversations about, budgetary concerns. And so in an effort to be, I guess, cooperative, what we'd have agreed is that child support will be due always on the first of every month, okay? However, it will not be deemed late until the first day of the next month. For example, February's child support payment will be due February 1st. February is a bad month because February changes. But if it is paid by the 28th or 29th, I guess, in a leap year, as long as it is paid within the month of February, it's timely. If it's paid March 1st, it's late. Okay? Is that clear?
Yes.
Okay. Now, additionally, with regard to child support, you've seen and you are aware, Ms. Perez, that there is a substantial amount of child support arrears owed to my client. Is that correct?
Correct.
Okay. And by my calculation, based on our most current schedule, we show the amount due and owing today to be $9,643.06. I've discussed that amount with you, have I not?
Yes.
Okay. And you agree that that is an accurate amount of what you owe my client?
Yes.
Okay. Now, what we've agreed to do, in the spirit of cooperation and to resolve this matter, is to set you on a payment plan for that amount, and that you will tender but in addition to, rather, your monthly child support, $100 each month towards this child support arrears. Correct?
Correct.
Okay. Now you understand that, well, maybe you don't understand, let me explain. In doing this, Clint has done you what I believe to be a kindness. I think he could have been far more aggressive in his pursuit of these funds. Okay, that's just my opinion. You don't have to assent to that. But what you do have to understand is that an essential term of our agreement is that if you should renege or fail to comply with the terms of this agreement, with the terms of this payment agreement, okay, that Mr. Kester is free to seek to enforce collecting those monies any way he wants, okay? And so you are in effect, and I'd ask you to affirm this on the record, that you are in effect confessing to judgment in the amount of $9,643.06 today, right? However, Is that, first of all, let me say, is that your understanding? Is that correct?
Yes.
You're consenting to judgment in that amount. Okay. Now, what we are doing and what our deal is that he will not seek to execute on that judgment to the full extent that he might otherwise be able to, so long as you make your $100 monthly payment each and every month. Okay, do you understand that?
Yes.
If you fail to do that, then you have you've forfeited the terms of that deal, and he is free to seek enforcing that judgment and any applicable interest and penalties and attorney's fees as he sees fit. Understand?
Yes.
Okay. We have discussed unreimbursed medical expenses and health insurance. Is that correct? You remember having those conversations? Okay. Specifically, you're unable to continue with the state health insurance that you were receiving, and as a result, my client has picked the children up on his health insurance and is covering them on his health insurance. And actually, he's doing so without requesting at this time any offset or reimbursement from you. He's simply paying for their health insurance, okay? So that's done. However, unreimbursed medical expenses are still something that will be divided and shared between you. What that means is that we're going to employ a common doctrine known as the 30-30 rule. Okay, and you and I talked about this in my office a bit, didn't we?
Yes.
Okay, but just for the record, I'll explain. The 30-30 rule means that whichever parent has the child in its custody, in their custody at a given time, the child needs medical attention, whether it be a prescription, whether it be a copay, whatever it might be. Okay, that parent will take the child and will pay for the service, whatever payment is needed, whether it's a copay payment or it's cash pay, whatever is needed, that parent will be responsible for making the payment. And then that parent will have 30 days from the date of the service with which to provide the other parent the proof of the bill and the proof of the payment. Correct?
Yes.
Can you understand that the person who receives that proof, then the non-paying parent, for example, then has 30 days within which to reimburse the parent who was out of pocket. Correct?
Correct.
Okay. Now, how are the penalties applied? Well, if the parent who incurs the cost doesn't give the proof of payment to the other parent within 30 days, they have waived their right to reimbursement, right?
Correct.
Okay. And in the alternative, if the parent who receives proof of payment fails to reimburse that parent within 30 days, they're in violation of the court's orders and subject to basically contempt. Is that clear to you?
Yes.
Okay. So that 30-30 rule will be in force and effect. We've also agreed that for all tax purposes, Mr. Kester Clint shall be entitled to claim both children on his income taxes each and every year for so long as he is eligible to do so. Okay? He shall be entitled to the tax credits associated with both children. Okay? That's clear?
Yes.
Okay. Okay, couple more brief terms. Part of what you have done and part of why I think we've resolved this case, Dawn, is recognizing how important, at this point in your life, sobriety and recovery are. Is that correct?
Correct.
Okay. And also therapeutic intervention for some of the painful experiences you've been through relative to domestic violence and abuse, correct?
Correct.
Okay. So part of and an essential term of our agreement is that you are going to maintain your sobriety. You're pledging to maintain sobriety, correct?
Correct.
You understand that not maintaining sobriety is going to be a substantial basis upon which to be back in court and basically losing a lot of what we've done here can be disturbed by that, correct? You understand that?
Yes.
Another way to say that is your sobriety is essential to these children's best interests, right?
Yes.
Okay, you understand that?
Yes.
Okay. You also understand that the court cannot restrict, nor does anybody want to restrict, whom you might have romantic relationships with. However, it seems to be very clear that one individual, and we've called him Cody, is it Greenfield?
Yes.
Is that right? Greenfield, okay. Mr. Greenfield, Cody Greenfield, it's a toxic relationship, one that has has caused you to suffer greatly, and I believe to be the victim of domestic violence. I hope personally for you that relationship no longer exists and that you steer clear of this individual. But nonetheless, an essential term of this agreement is that he shall never be around Kobe or Avery, correct?
Correct.
You understand that?
Yes.
And that is a non-starter. That is a major violation of the court order. Should that happen, almost certainly my client will seek sole custody of both children, okay? You understand that?
I do.
Okay, and you pledge that you will make sure that he's not around those kids.
Correct.
And please, for
Yes.
me, maybe think about for yourself, don't see this guy anymore, okay? You also, in addition to maintaining sobriety, you are participating in the Celebrate Recovery program, correct?
Yes.
And it is a 12-step religious-based recovery program?
Yes.
You understand that your continued involvement in that is mandatory as well, correct?
Yes.
Okay, and you pledge to continue to work your recovery program, correct?
Yes.
And from personal experience with family members, my understanding is that's not something that ends, right? That's a lifetime commitment, right?
Yes.
Okay, but you're going to do it, and I think you will. Additionally, you have been receiving some therapy and some treatment relative to dealing with sort of the insidious effects of domestic violence and that cycle of abuse, right? You've been going through some therapeutic, I believe, classes or counseling.
Counseling or therapy.
Okay. And you have pledged as part of this agreement that you will continue to maintain that counseling and that therapy, that will be part of what you do, almost part of your recovery, correct?
Yes.
Okay, and that is an essential part of this deal, that you continue to stay current and maintain that therapeutic intervention to help you learn the skills and hone the skills that you need to stay where you need to be, to see these relationships before you're in them, right?
Yes.
Okay, and we're going to do that. The only other piece I have is we discussed the issue of Avery's cell phone, correct?
Yes.
And without admitting that you do or don't, we have simply agreed that Avery's cell phone will not, to the greatest extent possible, will not be a means of punishment that you employ for Avery, meaning that he will not lose the right or access to that cellular device, correct?
Correct.
Okay. Now what we've discussed is no one, and certainly not me, I don't want to step into your home and be a parent for you, and I understand being a parent is difficult enough, okay? So what we've discussed is if for some reason Avery's behavior is so severe and you cannot fathom of another way to get through to him other than tampering with or restricting access to this device, that you would not do so without discussing that matter first with Mr. Kester, correct?
Correct.
And that you would seek first to get an agreement of Mr. Kester to maybe do that if you felt it was necessary, correct?
Correct.
And that if you did not reach an agreement, then your recourse would be to seek intervention from the court, correct?
Yes.
Okay. So we're just not going to do anything to sever his means of communication without either an agreement of my client or an order of the court, correct?
Correct.
Okay. And finally, Don, you're aware of the fact that Clint has spent a substantial amount of money in the prosecution of this case over a period of many years, right?
Yes.
And you know that there was a demand on the table for you to pay about $25,000 worth of his attorney's fees, correct?
Correct.
Okay. We discussed that in depth. And obviously, you understand that my client was very sincere, fervent, in fact, that he believed he was entitled to those monies. Is that right? You understand?
Yes,
You heard me
I
say
do
that?
understand.
Okay. Now, in talking to you, you've expressed to me the financial hardship that would cause you. Is that right?
Yes.
And I've looked at your finances, and in fairness, I can see that would have been a substantial impediment, I think, to your future success. And I discussed this with my client, and what we've agreed, and tell me if I'm stating this wrong, but what we've agreed is that the spirit of cooperation, consistent with your continued abidement by these terms, right? So what I mean is that your continued cooperation, your fulfillment of your obligations of this deal is the condition upon which he's willing to let go of that claim and say, we will each bear our own attorney's fees and costs, okay? With
Yes.
the expectation that that extra money in your pocket can maybe help you to continue the therapy, or maybe do some more, or maybe work with the kids, or do things to better your life and better these kids' lives, okay? That's the idea. But understand that what I mean by why I say essential term is, to the extent that we are back in court litigating these issues, either litigating your non-compliance with these issues, or litigating issues arising out of or related to the substance of what we've put on the record here today, the Clint's going to reserve the right to renew his request for fees, okay? Is that clear? You understand that?
Yes.
Right? So I want to make sure this is very clear, right? He's saying each to bear their own attorney's fees and costs. However, to the extent that we are back in court to litigate due to your non-compliance, he shall be able to seek retroactively seek the fees he's expended, okay?
Yes.
Sort of a carrot and a stick sort of deal, Don. Does it make sense? And I want to make sure that you understand it because it's important.
Yes, I understand.
Okay, okay. So, I think with that said, let me ask you some general questions. I know I talked a lot, I know there's a lot of things put on the record, but you and I spent quite a bit of time in my office hashing this out beforehand, correct?
Yes.
Okay. You've heard everything that I've said on the record here today, correct?
Correct.
Okay. And you've understood everything I've said on the record here today, is that right?
Yes.
Okay. And you are well rested, is that correct?
Correct.
Okay, you're sober today?
Yes.
Not taking any prescription medications or anything else that might interfere with your ability to competently testify here?
No, I'm not.
Okay. And I touched on this earlier, but I didn't promise you something in the back hallway to get you to agree to things. Nobody else made you any promises of any kind to induce you to enter into this agreement, did they?
No, they didn't.
Okay. And there's no other agreement that we signed in my office or any other, document that says something else somewhere that's really supposed to be binding, right?
Correct.
What we put on the record here today, and only what we put on the record here today, is our agreement.
Yes.
Okay. And you're entering into these agreements freely and voluntarily, right?
Yes.
Okay. And you believe, painful as it might be, and emotional as it might be, though, at the end of the day, these agreements to be in the best interest of your children, correct?
Correct.
That Avery and Kobe, that's who this is about, and we believe that everything we've done here today is what is best for them, right?
Yes.
Okay. We can go off.
We are off the record, 2:47. Back on the record, 2:48 p.m.
During that brief break, I just conferred with Ms. Perez, just made sure that you understood everything as clearly as possible, and wanted to make sure that if you had anything else, that you were able to air it and be clear about it. I know sometimes, sitting in front of a camera and with a court reporter sometimes is nerve-wracking. So before we concluded, I wanted to give you that opportunity. We took that opportunity, right?
Yes.
And to that effect, you had no further questions and you were in complete agreement still, correct?
Correct.
Okay. With that, we'll conclude today, and just for the record, so you know, this will be effectively the transcript of what will turn into a stipulated order. I will prepare that order for the court signature. If I can avoid it, I will try and avoid a court hearing. It's possible I can simply do it by summary disposition with your signature. In the alternative, we may have to go down there for a quick hearing and sort of do what we did today in front of the judge, but I'll try not to. And that'll conclude today, and then you obviously are entitled to review and sign off if you want, but I don't know why you'd want to do that, but she can kind of explain that to you when we're done, okay? Thank you for
Okay.
your time, and thank everybody else for their participation today.
Thank you.
We are off the record, 2:50 p.m.